Chapter 3 Mark Trade Name and Acts of Unfair Competition Objects. Upon completion of this chapter, you will be able to briefly describe what mark is, understand the conditions to protect mark trade name and acts of unfair competition, can determine the difference between collective mark and certification mark, determine the exclusive rights of the owner mark. One introduction mark was born a long time ago, more than 3,000 years ago. Indian artisans used to engrave their signatures on art products before sending them to sell in Iran. More than 100 pottery and other items were used, including the most famous Fortis brand, until it was copied and counterfeited as the brand flourished in the Middle Ages. Today, brands are often abbreviated TM in English, and most people around the world can distinguish two well-known beverage brands, soft drinks Pepsi-Cola and Coca-Cola. The strong growth of the brand in commercial activities is due to the increasing competitiveness of the company in doing business in many countries. Quality and price. Thus, a brand can be considered as the focal point of communication that uses any product of the manufacturer and the consumer of the goods. The vision of the brand in the past was to ensure the purity of the goods or to protect the public interest and to be able to easily execute the products on the market. But later on, there was a change in brand perception, either to determine the purity of the goods or to ensure the quality of consumers. Easy to choose goods, determine the type of goods or services. Market penetration, or for honest competition and dignity. 1-to-1 Paris Convention. The Paris Convention is the oldest international agreement covering industrial property, signed in 1883. This convention is an international agreement for setting minimum standards for the protection of intellectual property rights. 1-to-2 Purpose. This law aims to prevent unfair competition for traders. Protect the interests of consumers. Investors can show the ability to do business. At the same time, it helps to promote business activities, identify the products of the company, make it easier to choose products, compete freely in the market, determine the quality of goods, especially responsible for the products and all business activities of the owners. 2 Overview of Mark. 2-to-1 Mark. A mark is a visible sign and is used to differentiate a product or service offered by a merchant or other person. That is a very simple definition, but does not explain in detail what a brand is. What are the characteristics of a brand? Basically, a brand has two major characteristics that distinguish a brand. Must be distinct and free from imitation. Therefore, the official definition of the word mark is visual mark, distinguishing the distinctive features of each enterprise product or service. All goods or services are classified into 45 classes based on the NICE convention. From Class 1 to Class 34 for use with goods called trademarks, and from Class 35 to Class 45 for use with services called trademark services. Marks can be words, drawings, letters, acronyms, packaging, slogans or logos, colors, smells, sounds. Like the Coca-Cola Company registered, PepsiCo, Inc. registered. Trademarks are very important. Branding services are also trademarks. But one difference is the protection of the brand on the goods and the protection of the services. Marks can look like letters, numbers, acronyms or other names such as last name, signature, symbol, color, etc. We only think of producing a well-known car brand, for example, Ford, after Henry Ford, the first manufacturer, and then Sakichi Toyota, the first Toyota car investor in 1924, and so on. See the use of abbreviated names, such as IBM as mark, but the brand can be used on indicated devices or components, such as Shell. Recently, we see a lot of new brands appearing on the market. Be it an animated mark or a brand image that can fluctuate depending on its edge when we look at its location. Brands or the sound of advertising slogans can be considered a trademark. In some countries, even the smell is a protected brand. Many different types of marks can be used as trademarks, but based on the same two conditions. The brand must be different and not fake. There are two types of trademarks and service marks. Trademarks used on goods are called trademarks. Trademarks used on services are called trademark services. To distinguish between goods and services, as mentioned above, there is a good example. Apple is not related to computers, which is very different from computers because it cannot be confused with products. On the other hand, anyone who brings or sells apples cannot register the word apple as a trademark to protect, because his competitors can use this word to describe the product. How many if we do not make a description, but can also describe the type of identity of the goods or services used? Others do not. For example, counterfeiting occurs when the goods are of good quality and no one else is present. Real animal skin or good quality like rice is not pure Batambang rice, just wear mark, causing buyers to confuse the goods. One of the main points raised is that when evaluating the differences of one of mark's signs is judged together with the goods or services that are together. 2-to-2 territorial view of trademark registration of a trademark is valid within the territory of the whole country is not only valid in Phnom Penh or in the provinces. To do business in the country, you should register as a trademark or service mark in the country. 2-to-3 mark collective. It is a visual mark that identifies the origin of goods or services, or identifies other common characteristics, including the quality of goods or services of different enterprises. Use of the trademark is under the control of the registered collective trademark owner. Collective trademarks are owned by associations or subsidiaries whose members use the trademark to identify their products by specifying the quality or authenticity of their geographical location or features. However, a collective brand can be used by other merchants who are members of its group. Collective brands are as follows. Ownership, generally a legal entity. Trading is an individual member. Brand usage, only members use. Limitations, subject to set internal regulations. Raw material, subject to internal regulations. A collective brand is a publicity about the features of a product that the collective brand uses or an enterprise that uses it. For example, an association of architects, engineers, their members may use the association's logo. 2-4 certification marks. A trademark is the name of a trademark or logo or assembly of such marks which indicates that the goods or services are related to the trademark used in the certification of the registered trademark owner, or provide quality services, clarity, or other characteristics. A trademark is a mark used to determine the quality standards of the goods, used to certify the quality of the goods that the brand is used to certify the authenticity of quality products or other features. Certification brands are used to set standards, for example, ISO 9000. The difference between a collective trademark and a trademark is that a collective trademark can be used by a member of an association or a group member who owns it, while a trademark can be used by someone other than a member in accordance with established standards. Collective and licensed trademarks are collective trademarks used for the enterprises of the association. Ownership can be a legal entity or an association. Trading is not an individual member. Brand usage can be used by others. Limitations, there may be limits or limits. Raw materials can be from other places or limited. Some companies are successful in branding and branding services around the world, where customers do not need to know the identity of a product or service or a particular type of product of a company or where it is manufactured. Well-known brands such as Apple, Sony, Samsung, LG, Versace, and so on. Many companies want to mislead those famous brands by creating similar brands that confuse customers. To avoid this, the Paris Convention, the TRIPS Agreement, and several national laws protect these well-known brands. There is no definite definition of a well-known brand, however. There are a number of factors that define a well-known brand, including the level of knowledge or brand recognition everywhere from the public over a period of time and so on in all geographical areas. Trademark protection is not available in the world. Just register in one country. You have to go to register in different countries according to the copyright law. The trademark is a right in territorial integrity. Territorial principle means that the protection of their rights is obtained through national registration. There is a regional registration system that makes it easy to register a trademark. An international treaty. Registration in a country is the domain of the competent authority of that country. Some are not members of the United Nations. However, there are some administrative procedures in that territory and trademark registration. A good example is that Hong Kong has a different trademark registration system than China. So if we want to protect a brand in Hong Kong, they have a Hong Kong-style registration procedure. Therefore, in order to protect the trademark in every country you want to use, there are different procedures in each country's national legal system. Make the brand easier and the procedure simpler. The Trademark Convention was adopted in 1994 and states that the national information of the member states must follow the procedures for registration of trademark protection at the Trademark Registry Office of each member state. Two to five well-known mark. The term well-known mark refers to a mark that is widely known to the public through its widespread and relentless use. The use of the mark in connection with other goods or services by other parties may be considered as an indication of the relationship between the two parties. Well-known mark is entitled to protection without registration. Article 6 bis, protection of well-known marks. The countries of the Federation are responsible for the protection of well-known marks. If their laws permit or at the request of the requesting party to deny or cancel the registration of well-known marks or prohibit the use of well-known brands leads to fraud. 3 various forms of mark. There are many different types of markers: letters, acronyms, names, lines, numbers, colors, logos, 3-dimensional shapes, sounds, smells, or a mix of color lines, numbers. 3 to 1 letter mark. 1 or 2 letters cannot be protected because they cannot distinguish the difference, so one character cannot be protected. But 1 or 2 letters in the form or pattern can be protected of protection. If 1 or 2 letters have the form of a pattern, it can be considered as device. Image format can be protected by distinguishing features by declaring unprotected 1 or 2 characters. 3 to 2 mark is a word. These include the Adidas, Starbucks, Whirlpool, Nestlé, Volkswagen, Sony, Harley Davidson, Philips, Just Do It, Orange, Siemens, Lay's, Red Bull, Java, Vodafone, JVC, Gatorade, Coca-Cola, Shell, Ford, Apple, Levi's, Rolex, Microsoft, PepsiCo, Ray-Ban. 1 or more separate words, whether combined or not, can be listed as protected. Separate words should be declared unprotected. For example, Gold Star for clock, disclaimer. Gold Kodak for film, Apple for computer. 3 to 3 name mark. Different names can be registered for protection, such as Honda for motorcycles, McDonald for fast food services. 3 to 4 number mark. The 1-digit number cannot be protected, so it is not protected in Cambodia. The feature is different but must be declared unprotected on the normal 1-digit number. A combination of numbers and letters can be registered because they are different. 3 to 5 mark. Logo. 3 to 6 mark. 3D. 3 to 7 devices mark. 3 to 8 signature mark. 3 to 9 combination mark.